Supreme Court orders new trial for Oklahoma death row inmate Richard Glossip. A fractured Supreme Court on Tuesday ordered a new trial for Oklahoma death row inmate Richard Glossip, whose appeal drew national attention and support from the state's conservative attorney general, in light of allegations that the state withheld evidence related to its main witness. The ruling is a major win for Glossip, whose 1998 conviction for arranging the murder of Barry Van Treese a year earlier has been called into question by him and, critically, the state attorney general after new evidence emerged in recent years. The ruling represents an extraordinary twist in the legal saga surrounding Glossip, who has been scheduled for execution 9 times and has eaten his last meal 3 times only to have his execution stayed. We conclude that the prosecution violated its constitutional obligation to correct false testimony. Justice Sonia Sotomayor wrote for the majority. The center of the appeal are notes taken by prosecutors involved in Glossip's trial about Justin Sneed, the man who killed Van Treese with a baseball bat in a hotel. Even though both sides agree Sneed killed Van Treese, Glossip was charged with orchestrating the murder. Glossip's conviction rested on Sneed's testimony, but years afterward, the state disclosed evidence that Sneed was treated for a serious psychiatric condition. The notes indicate prosecutors knew about Sneed's diagnosis and treatment at the time of Glossip's trial and, according to Glossip's supporters, hid that information from his defense. Had the prosecution corrected Sneed on the stand, his credibility plainly would have suffered. That correction would have revealed to the jury not just that Sneed was untrustworthy, as amicus points out, the jury already knew he repeatedly lied to the police, but also that Sneed was willing to lie to them under oath, Sotomayor wrote. Such a revelation would be significant in any case, and was especially so here where Sneed was already nobody's idea of a strong witness. 5 justices sided with Glossip on ordering a new trial. 2 conservative justices, Clarence Thomas and Samuel Alito, dissented. Conservative Justice Amy Coney Barrett would have sent the case back to a lower court for further consideration. Thomas, writing in a dissent joined by Alito, argued the court's decision imagines a constitutional violation where none occurred, and abandons basic principles governing how federal courts review state court decisions. During oral arguments in October, several members of the court seemed puzzled by the scant record surrounding the notes, including liberal Justice Ketanji Brown Jackson, who said at one point, "It's my understanding that there's never been a court determination of any of these facts," and Alito, who described the notes as cryptic.